have a seat.
Good morning.
Good morning.
Would you tell us your full name, spell your last name, please?
Gianna Torchia, Torchia.
Ms. Torchia, did you at one time work for an attorney by June of 2018? Would you have been employed under Ms. Murphy's guidance?
Yes, sir.
Exchange an email with Detective Gillum on June 5th, 2018.
Yes, sir.
Did you have an opportunity to review it?
Yes, sir.
I'm going to pass to you, Ms. Torchia, what I've marked as Defendant's Exhibit number 25. Thank you. And ask you if you can identify it for us.
Yes, sir.
What is it?
Email from Detective Gillum.
And is it a response to your initial email to him?
Him.
Oh, true and accurate. Your email to him and Detective Gillum's response.
Yes, sir.
Move to introduce it into evidence at this point, Your Honor, Defense Exhibit 25. All right.
Defendant Exhibit 25 will be received.
Ms. Torchia, did you on this day send Detective Gillum a copy of the South Carolina Domestic Violence Restraining Order?
No, because we were one.
Okay.
He does send me a copy of the order, but there was never an order entered into the Charleston County Clerk's or the Sheriff's Office.
Yeah.
So we had no proof of an order at the time.
Would you please read for us Detective Gillum's response to you on Tuesday, June 5th, 2018,
Gina,
6:19 p.m.?
I noticed something that you both need to be aware of, unless there's something I'm missing. If you read that section just before the judge's signature, it states the order will be in place 6 months of the day of the hearing, which was May.
Can you slow down just a little bit?
Oh, I'm so sorry. I'm a fast reader.
Okay. Well,
Sorry about
slow
that.
down a little bit for us.
Evelyn Wood School, huh?
Where do you want me?
You're good.
Okay.
6 months of the day of the hearing.
Which was May, November, which was May, November 3rd.
Ms. Torchia,
Yes.
I'm sorry. Would you start over, please?
Yes, sir. Gina, I noticed both need to be aware of, unless there's something I am missing. If you read that section just before the judge's signature, it states the order will be for 6 months of the day of the hearing, which was May, November 3rd, not November 27th, and sets it to expire May 3rd, which would be 6 months from November 3rd. Again, would have made a physical arrest on, but the SAO will at some point make a filing decision. If I am reading something wrong here, let me know.
Okay. We can agree that SAO would be state attorney.
Yes, sir.
So, lastly, Ms. Torchia, this is Detective Gillum telling you that the order was in a stay-away order
Objection.
as of November 3rd, 2017, correct?
Objection.
Sustained.
This is Detective Gillum explaining to you.
Objection. She read the email.
Sustained.
Just a moment, Your Honor. This is
Yes, and there's also
no further questions, Your Honor. Thank you, Ms. Torchia.
All right. Any cross?
Can you finish your answer, please?
Yes. There's also a predicament where there was no order entered in to the clerk system in Charles. He had no bounds to make an arrest just based on this when it wasn't entered.
Further questions?
Disregard,
Thank
Your
you.
Honor.
Members of the jury, testimony regarding witness about violation of criminal law is inappropriate. We disregard those last comments. Anything else?
Sufficient, thank you, Judge.
Rita Rep?
No.
Yeah.
Ma'am, you're released from your subpoena.
Would you like to? Thank you.
Mr. Taylor?
I wonder if we could publish.
I think it's a great time for our mid-morning break. See you back in a few minutes. Y'all can have a seat. All right, so the issue is a police report that I haven't seen, but it's my understanding what it says is that Ms. Benefield went physically to the telephone reporting unit of the Manatee County Sheriff's Office. I'm going to summarize, you can correct me. All right, so this isn't marked. Is it? Did you seek to admit it as an exhibit or just testimony?
No, just testimony.
All right, so you expect the testimony would be from a deputy with the sheriff's office that Ms. Benefield went to the telephone reporting unit on December 6, 2019, that Ms. Benefield wanted to document the fact that her estranged husband admitted in a text message that he placed a tracking device on her vehicle in the past, that she has observed him driving behind her on multiple occasions, which concerns her, and she wanted this information documented. She brought her vehicle to a local auto dealer, but a tracker could not be found. Due to the fact a tracking device was never observed on the vehicle, an information report was completed. All right, any objection?
Objection, judges, that anything contained in this report, which the nature of this report, according to it, is information, but anything contained in this report is hearsay other than that Ms. Benefield physically appeared at TRU on December 6, 2019, because everything that Mr. Deputy Lindsay wrote down was told to him by Ms. Benefield. And so the state would object to his being able to testify to anything other than she appeared at TRU on that date, which seems irrelevant, if he remembers.
Proponent, defense?
Yes, so it clearly goes to her state of mind at the time, and it also corroborates her defense. I do not plan to ask the deputy to read it. I'm going to ask him if he took a report from Ms. Benefield, what the date was, and whether or not it was her reporting about a tracker being placed on her vehicle. That's all.
And that's hearsay, and because it's self-serving hearsay. It's actually hearsay within hearsay, I think. That if he wrote something and asking him what he wrote in a report about somebody else told him, but it's at least one level.
All right, thank you both very much. The purported reason for the introduction of this testimony, according to the defense, is to show the defendant's state of mind and that it corroborates her defense. Both of those sound to me like the introduction of this report to the sheriff's office regarding a tracker is being offered for the truth of the matter asserted that a tracker was placed. That would obviously make this hearsay. It's the introduction of an out-of-court statement to prove the truth of the matter asserted. That being that a tracker was placed on her vehicle, thereby corroborating the testimony that has already been provided. My notes are that it's already been testified to that the tracker was placed on the defendant's vehicle. And my notes are that she testified, or it's been established, that the victim in this particular case admitted that he placed it on her vehicle.
Yes.
So that's already in, and I think I said this the other day, and it bears repeating. So this is self-serving hearsay. It's clearly excluded. I will just note a secondary reason would be the relevance of this report. The issue is not whether or not she reported it to the authorities. The issue is not whether it's true or it's not true. The case law is very clear on this. It's not relevant whether law enforcement believed her or didn't believe her. The purpose of allowing these prior bad acts, and I say prior bad acts instead of going into all the different ways that can be done, but in a self-defense case, once the defendant has established there was an overt act, prior incidents of violence and intimidation and threats can come into evidence. The case law is very clear. They may be true, they may not be true. The issue is, what did the defendant know on the day that the force was used? And so those prior acts of the specific incidences of prior bad acts or prior violence don't have to have happened to her. She just has to know about them. And the tracker issue, while not necessarily violent, certainly it's intimidating. And I allowed it. I don't remember if the state objected or not, but I allowed that in. The testimony is in. Whether she reported it to law enforcement is of no moment. Whether it's true or not, because put it this way, the tracker wasn't found, so it was just an information report. It doesn't matter if it was found or not. It doesn't matter if this officer believed her or not. The issue is, it's something she's aware of. She testified to an overt act. It's already in evidence. So at this point, this is not marked. What was who was the next person? What was his name or her name?
Lindsay.
That was Deputy Lindell.
Lindsay. Scott
Lindsay.
It's on the top of the report.
Scott Lindsay, I'm sorry. Lindsey.
So you could call him, but the substance of her walking in, him taking a report, again, none of that is relevant to the issue of her knowledge of prior incidents.
That's all I was calling him for, so, yeah.
All right, I do want to give you all a break, though. I know we started at 9. It's about 10:30. I think it's reasonable to go ahead and take a break. So why don't you guys take 10 minutes?
Yes.
Witness. Welcome back, everybody. We are back on the record.
Please have your seat, please.
Mr. Taylor, do you have your next witness?
Defense calls Vincent Vizzaccaro.
You ready?
Yes.
Okay, yeah, let's go ahead and bring him in. Please make sure you have him spell that for the court reporter. Do you need the...
Please.
But we'll wait to turn the lights down until you give us the high sign and the clerk will turn them down.
All right.
All right, you all can have a seat. Welcome back, everybody. Hope you got to stretch a little bit. Maybe run and jog in place, warm up a little. So we've got the defense going to call their next witness, but before we do that, I did want to ask that anybody begin deliberations amongst yourself, speak with anybody outside of the jury about the case, or do any research on those topics we've talked about. Mr. Taylor, call your next witness, please.
Thank you. Vincent Vizzaccaro.
Do you solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Hello, sir. As the deputy said, just make yourself comfortable in that chair. My name is Judge Whyte. I'm going to be presiding over the case. You can adjust that microphone up, down, left, right as you need. Stay about 12 to 15 inches away. Speak in a loud, clear voice. It'll pick up everything.
Sounds good.
Good morning.
Morning.
Would you tell us your full name and spell your last name for us, please?
Vincent Vizzaccaro, Vizzaccaro.
All right, Mr. Vizzaccaro, I'd like you to try to keep your voice up if you could.
Will do.
What do you do for a living, sir?
I'm in real estate.
And where are you a realtor?
Lakewood Ranch, Bradenton, and Sarasota areas.
Do you have any particular specialty?
Residential homes in Lakewood Ranch.
How long have you been doing that?
About 8 years now.
I want to ask you whether or not back in 2018, you had occasion to deal with an individual by the name of Douglas Benefield.
Yes, I did.
Would you tell us the circumstances under which that relationship took place?
Yes, he contacted me looking for a home.
Hearsay.
I'll overrule at this point.
Thank you, Judge. Contacted you looking for a home?
Looking for a home he was trying to acquire through a business that he said he owned in Lakewood Ranch.
All right. And back in 2018, Mr. Vizzaccaro, did you use emails to communicate with him?
I did.
And did he communicate with you in the same fashion?
Yes, he did.
Were emails back then a normal and customary part of your business?
Very much so, yes.
Did you preserve the emails as they related to each client's files?
I do that, yes.
And were the emails under your care and custody?
Yes.
Mr. Vizzaccaro, I'm going to pass to you what we've marked as defense exhibit number 27.
Can we approach, Jen?
Yes. My responsibility. All right, here's the jury. I do need a few minutes to resolve a legal issue. That's my responsibility. So if you could, close up your notes and leave them there on your chair. And I'm going to excuse you back into the jury room for a couple of minutes. I will get you back out here as soon as I can. Don't begin deliberations. Don't talk with anybody outside the jury. And no research on any of the issues. Mr. Vizzaccaro, what I'm going to do is at this moment, I need to do some research and speak with the attorneys.
Okay.
So I'm going to excuse you to the hallway. There's a thing called the rule of sequestration that has been requested by both parties. And that means that you cannot discuss your testimony or the questions asked or anything you need to know about right now. All right, I'm just going to ask before I start doing my research, do you have any cases that you want me to know about right now?
No, Your Honor.
All right, so let's, I'm sorry, go ahead.
We're traveling under the words in the statute, specifically 9803 6.
Understood. All right, so I'm thinking it's going to, I need about 10 minutes or so. So we're going to take a 10-minute recess, maybe 15-minute recess. I want to look this up as well because I want to find a case that gives me some direction.
Okay, yes, sir. Thank you.
Any other objections?
Judge, also, I would like to make a relevance argument that the fact that he's going back and forth in this email about a specific property, there's no relevance to it.
All right, proponent, go ahead, sir.
Well, I think it's admissible, one, as a business record, which we've already qualified. Business records traditionally contain hearsay, and under the statute, Your Honor, specifically subsection C, we got this email from the state. However, we then gave it back to the state in its isolated form. They have not filed any objection to it, so they've waived that objection according to the business records exception. We also believe that it shows Doug Benefield's state of mind that he was in the process of buying a home directly behind Ashley Benefield's home during the time period when the South Carolina injunction was in full force and effect.
All right, anything else, sir?
No, sir.
State.
Judge, I found a case I would like to put on the record. Thomas v. State, 993 Southern 2nd 105 from 2008. It is specifically addressing an email that was put in as a business record. You have long to read this, but it was an email that was sent to an apartment complex manager of some sort, and it appears as though it was not qualifying as a business record, and additionally the hearsay within the email was not admissible. There is a yellow flag, and I'm trying to look at it now.
did you review Thomas v. State, Mr. Taylor?
Yes, sir.
All right, do you want to make any argument on it?
No, sir.
So Thomas v. State is helpful. It's 993 Southern 2nd 105 First DCA. Although it was the state introducing the email against the defendant, the state sought to introduce an email that was prepared by an employee of the apartment complex where the victim lived and was murdered regarding statements made by the victim that she had someone living with her that was not on the lease for a year and she wanted that person out. And obviously the state was introducing that to prove that that was the defendant and that the victim was trying to evict him, and that was part of the reason why he then murdered her. And the first DCA found that even if the email from the employee's side qualified as a business record, I don't see where they actually found and held that the email was a business record, which was my original question. But ultimately concluded that the statements that were made and then by the employee and then communicated through that business record, those statements were not, well, first they're hearsay, but they were not part of the records and the data compilations of the business itself. And that although hearsay may exist within exhibits that fall within an exception, such as business records, those hearsay statements must still qualify under a separate exception to the hearsay rule. And in this particular situation, if I'm understanding correctly, what the defense is asking is to introduce Defendant's Exhibit 27 through Mr. Vizzaccaro as his business record that he keeps. But according to Thomas, and then they also cited a prior case of theirs, Vincent v. State, Vanzant, 372 Southern 2nd 502, Florida 1st DCA 1979. Even if this qualifies as a business record, which again, I have not found a single case that says it does or doesn't, and I don't see in my review of Thomas where it says it is or isn't. But the statements of Mr. Benefield are being offered to prove the truth of the matter that he's looking to buy a house in Lakewood Ranch are hearsay without exception.
But the exception, Your Honor, is his state of mind. It clearly shows Mr. Benefield, let's not forget what the defense is here. The court's allowed me now to bring in evidence of domestic violence. And here is Mr. Benefield, Judge Whyte, negotiating with the Realtor to buy the house directly behind the home where Ashley Benefield lives. And he's doing it at the time the South Carolina domestic violence injunction prohibits that. He would not be able to buy that house directly behind Ashley Benefield's home. It's like 200 feet away, 100 feet away. And it's a continued pattern and practice corroborates the defense.
Do you want to be heard on 90.8033, then existing mental, emotional, or physical condition?
Judge, his mental state, that still has to be material to a material fact. And his state of mind at that time is not a material fact. Also, I think the defense is misrepresenting some of what's in the email. Mr. Benefield never said he wanted to buy the house. He said he wanted to rent the house, and he said, I'll have to check with Ashley first. So I think some of the misrepresentation that's going on, we should probably just read the email. But I don't think it has anything to do with his state of mind. His state of mind at this point in time is not relevant.
All right, as I've said before, are you going to establish the location of the home through Vizzaccaro,
Yes, sir.
where it was,
Yes, sir.
in relation to the house where Miss Benefield lived?
Yes, sir.
And then are you going to then just argue during closing, I would assume?
Yes.
All right, so there's going to be no more witnesses. This is the end of this road to establish
Yes. This is just
witness-wise.
This is an isolated act of DV. Yes.
All right.
Judge, if she didn't actually know about this, then I don't know that it's relevant.
Well, and that's what I was thinking because, hold on, It's not an act of violence, though.
Right.
Or threat. But under 9803 subsection 3, a statement of the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, design, when it's offered to prove the declarant's state of mind, emotion, or physical sensation at the time or any other time, or prove or explain acts of subsequent conduct of the declarant.
Then, Judge, I would just ask that this witness be asked questions if he is allowed to testify. I don't know why we even have to speak about an email. Just, were you helping Doug Benefield and were you looking at a certain house?
I think that would obviate some of the evidentiary concerns I have, that you asked if he was assisting him in finding a location. Did you find one? Where was that location at that you were talking about putting an offer on?
Indeed, and if the court rules against the admissibility of the email, that would be my intention. On behalf of Ms. Benefield, though, I would like to present the best defense that I can. And I think that the email clearly is something the jurors can have, read, see. It's tangible. It has the same kind of impact, Judge, that the prior inconsistent statement of Gillum or the emails involving Stephanie Murphy does. And in the absence of a reason why it should be kept out, I would like to admit it.
All right. Thank you both very much. I'll allow the admission of Defendant's Exhibit 27 under 90.803(6) for the Realtor's portion and 9803(3) for the Benefield portion. With the understanding that, again, this is a relatively collateral matter.
In and out, Judge.
All right, can you bring the witness back in, Mr. Vizzaccaro? All right, welcome back, sir. Just take your spot back there in that chair. We're going to get the jury back in and begin your testimony.
Sounds good. Thank you. Gosh, is it coming this way?
It's up to you. All right, y'all can have a seat. Welcome back, everybody. Get ready to begin deliberations. Talk with anybody outside the jury about the case or do any research. Mr. Taylor, you may resume your direct examination.
Thank you, Judge Whyte. Mr. Vizzaccaro, when we last broke, you told us you were a realtor and that Douglas Benefield had contacted you relative to a house in Lakewood Ranch.
That's correct.
All right, I'm going to pass to you, Mr. Vizzaccaro, what I've had marked as Defendant's Exhibit number 27. That would be the email messages that you referred to before when we were last in front of the jury, correct?
Correct.
Is that a true and accurate copy of the email exchange between you and Douglas Benefield?
Yes.
What is the date of that exchange?
The last email I see here was March 12th of 2018.
March 12th, 2018. Your Honor, at this time, I would move to introduce that into evidence on behalf of Ms. Benefield.
All right, same objections, overruled. Defendant's Exhibit 27 will be received.
Now, Mr. Vizzaccaro, I know you've told us that the home, do you recall the address of the home?
Yes.
What was it?
5060 Newport News Circle.
All right, I'd like, with the court's permission, to dim the lights, and we're going to put a diagram up there for you. And as luck would have it, you have the pointer. Okay, so this will give you
The beam?
Okay. Would you please show us on that diagram where the house was that Mr. Benefield contacted you about purchasing?
This one right here.
Right there. Now, that house, is it directly behind the house in front of it with a red dot on it?
Yes. Yes, it is.
Okay. Do you know, Mr. Vizzaccaro, who was living in the house with the red dot at 11331 White Rock Terrace?
No, I don't.
And do you know whether or not, if I may, you know whether or not you don't know who is living in this house?
No.
This is the house that Mr. Benefield was interested in purchasing.
Correct.
Do you know whether or not Mr. John Sant lived in that house?
I don't know.
Give me just a moment, Your Honor. I don't believe I have anything further. Okay. Should I continue? Mr. Vizzaccaro, my oversight. I'm going to pass to you what I've marked as Defendant's Exhibit Number 28 and ask you if you can identify it.
Yes, that's the house.
That's the house that Douglas Benefield had contacted you about purchasing.
Correct.
And is that in Exhibit 28 a true and accurate reflection of the locale?
Yes,
Does it have a dot on it?
it does.
Does it have an address?
It does.
What is the address?
5060 Newport Circle. Newport New Circle,
On
excuse me.
behalf of Ms. Benefield, Your Honor, move to introduce that as Defendant Exhibit 28.
No objection.
Received.
That's all. Thank you very much, Mr. Vizzaccaro.
Gotcha.
Cross.
So you've had the opportunity to review the email, correct?
Yes, I have.
If I could just, and for the record, this is State's Exhibit 27. And it appears as though you're speaking with Mr. Benefield about potentially this house coming up, or the price being lowered on this house, correct?
That's correct, yes.
All right. So you were contacting Mr. Benefield about it?
I reached out to him about that.
Okay. And he actually said he may just want to rent. Isn't that correct?
That is correct.
And he also said he didn't want to do anything without speaking to Ashley first.
That was a comment that was later in the conversation, yes.
Okay. And if I could show you State's Exhibit 27, it's very small type at the top, so he might be able to.
That's why.
I'm sorry, Defense Exhibit 27. Does he say there that he needs to speak with Ashley first?
It appears that way, yes.
Okay.
Yep.
Thank you. No further questions.
Can you redirect?
Nope.
Can the witness be released?
Yes, sir.
Ma'am?
Yes.
All right, sir, you're released from your subpoena. You're free to go.
Thank you.
Mr. Taylor, can you state, defense, can you approach real quick?
Defense would call, Your Honor, Dr. Jason Quintel.
Hello, doctor. Welcome back.
Hi there, thank you.
Good afternoon, Dr. Quintel.
Hi there,
Welcome back.
thank you.
As a result of the counseling sessions that you had with Douglas Benefield, did you reach any conclusions with respect to Doug?
Objection. Improper testimony. Opinion testimony.
Can you go ahead and approach?
Dr. Quintel, so a couple of questions about your practice.
Yes, sir,
I think you told us your specialty was trauma.
correct.
And for purposes of practicing your profession, various clients come to you and relate their backgrounds, correct?
Various people come to me and they've had traumatic experiences in their background. Some may be upfront in presenting them, some may not, but purpose of treatment is to get now to work better, and sometimes that requires unplugging and healing emotional wounds from the past.
And as part of your art and science, you are trained in picking up and diagnosing various cues in your effort to reach conclusions to try and help them.
I'm not following the question.
As part of your practice, you're trained in being able to observe and detect various cues from these patients, are you not?
What do you mean by cues?
Indications of areas of trouble. For example, you don't always have patients that come out and say, oh, I am traumatized because of this. Rather, they may speak in obtuse terms, and you are charged with, among other things, trying to figure out where the trauma lies and why.
I would answer that slightly different than the way that you're framing the question. So when somebody comes in to see me, my job is to understand what's not working and really what's not working in their life today. If that leads us to unplugging earlier trauma, which frequently it does, great. But that's the purpose when they first come in, is me understanding what's going on with them today that's not working, and hopefully saying it back to them in a way that they're getting it, that I understand.
And in that process, you rely upon various statistical manuals and things that are reflective of your profession, do you not?
I don't do specifically a lot of diagnosing, so I'm not going to use the DSM frequently. I'm going to understand the background of why trauma sticks and how to get that better.
And to understand the background of trauma, have you in the past, or do you periodically consult learned treatises and periodicals, things that help you to reach that understanding?
If you're asking, do I go to continued ongoing training and development? Yes.
All right. Now, in this particular case, did you reach some conclusions about Douglas Benefield?
Objection. Qualifications.
Sustained.
Did you counsel Douglas Benefield?
I did, yes. Both Ashley and Doug.
All right. And in counseling Douglas Benefield, did you listen and absorb the various points that he was making to you?
Yes, both when they came in as a couple and then when I did individual therapy with them separately.
And when they were in there as a couple, was part of your process observing the dynamics between the two of them?
I wanted to understand why they were seeing me and what stuff we wanted to get better. So certainly I'm paying attention to what they're telling me, what they're communicating, and such.
And part of that included how they acted when they were together and how they acted when you saw them separately.
Yes, I would say so.
Now, in making those observations and questioning them and listening to them, in your effort to try and identify the objective, did you reach some conclusions about Douglas Benefield?
Objection. Foundation.
Would you approach, please?
Plus, degrees you hold.
So I have a bachelor's in psychology, a master's in social work, and a PhD in clinical sexology.
How long have you been practicing as a psychologist?
I got my master's in 98 and started working in the public school system. So since 98, 2006, I started a private practice.
And since you've been in private practice, can you give us an idea of the number of patients that you've seen and counseled?
Thousands.
And your specialty in counseling patients runs to all three of those fields that you have degrees in?
Yes, I have a background in all of that, but my specialty is in trauma resolution.
And when we speak of trauma resolution, explain to us what that is.
So I think the first thing that somebody has to understand is trauma, or what we go through, isn't troubling because it happened, which is the conventional wisdom, is that because it was awful, it still hurts. But we're not troubled because it was bad. We're troubled because when it happened, emotionally the brain short-circuited and doesn't know that particular experience ever ended. So where therapy missed the boat is we felt that people buried and repressed, and we have to help them process and get it out of them. Where the methodology that I use is the reverse. It's about getting the good news in to the emotional part of the brain that doesn't know it's over. Think of it more like unplugging the memory, so emotionally the brain can read it as data about something that happened versus where it's been stuck as happening, which explains why when somebody frequently either talks about it, is reminded of it, or is in something similar to it, emotionally they're transported back to that awful moment. Right? If you have a friend telling you about something that was troubling them, and as they're telling you about it, it's almost as if they go back there to that troubling moment. So our goal is to keep the person more emotionally present as we unplug the emotional effect that the past has had.
And in that process, do you typically employ listening to patients?
Yes.
Do you typically employ making suggestions to patients?
I don't know if I would say it's making suggestions versus more having a mutual outcome of how we want them to be in mind. So if I'm creating a future self or an outcome, it's got to be something that they're good with, or if it shows up as conflictual, we're never going to be able to reach the outcome. So more instead of a suggestion, it's more of a mutual outcome.
All right, and you went through this process with both Doug and Ashley Benefield.
I did, yes.
Your Honor, I would tender Dr. Quintel as an expert in the field of psychology.
Do you want to voir dire witness?
Objection.
Do you want to voir dire the witness as to experience, training, and knowledge?
Yes.
All right.
You do most of your work now in trauma resolution, correct?
I do, yes.
And how long have you done trauma resolution?
Since 2006, October.
So for many years. And you said you don't do diagnoses anymore, correct?
I don't look at diagnoses with people, I look at people, because the notion of the diagnosis will help in understanding maybe some of the background of why somebody acts, but you're really working with the person. So if somebody says to me, do you treat OCD or bipolar, I would say I work with people, not the disorder.
So when you're dealing with, for instance, Doug and Ashley Benefield, you're not doing so in order to create a diagnosis or evaluate. I guess what I'm trying to get at is there's a difference between therapy and a diagnostic evaluation.
Yes, ma'am.
Okay. And so your relationship with them was what?
They were referred to me by another therapist, and my job was to do trauma resolution. What I was told is that both had their own trauma. There was some stuff within the relationship, and that I was tasked with unplugging the emotional effect of those experiences.
Thank you for this question.
You may resume your question.
So in treating people, not the disorder, you still, though, do you not have the capacity and the training and experience to understand if a disorder is present?
Yes, sir.
At this point, Your Honor, I would now tender Dr. Quintel as an expert.
And I
You know,
would
we've heard
object.
Same objections?
Same objection.
All right, I will rule the objections goes to weight, not admissibility. Go ahead, sir.
Thank you. So, Dr. Quintel, all right, we're rolling. Did you reach any conclusions with respect to Douglas Benefield?
Yes.
Would you tell us what those were?
Based on the conversations with both Ashley and Doug, Doug occurred as someone who was domineering, and the terminology that I would use at times would be super controlling. He was very dedicated to wanting the relationship to work. He was very interested, despite conversations with some of the disparaging things that Ashley had said to him. He was very much still wanting this to work, and their plans were to move to Maryland.
All right. Did you reach any conclusions with respect to him being a real alpha male?
I would say that Doug occurred as somebody who was very built and well put together. And yes, I would say that he would fit the stereotype of an alpha male, in my opinion.
Did you conclude whether there was an intimidation issue present?
Ashley stated that she was scared of Doug.
Did you reach any conclusion, Dr. Quintel, about whether Doug's depiction of himself as being godly was reliable?
Objection outside of expertise?
You can answer.
Can you say that again, please?
Sure. Did you reach any conclusion with respect to Doug's presentation of himself as being particularly godly?
Yes, I think it was over the top.
All right, and did you reach any conclusion as to whether it was genuine?
I did not think it was fully genuine, no.
Did there come a time when you inquired of Doug why he would want to remain in this relationship.
Yes, I did.
Why did you do that?
Actually had a lot of disparaging comments, stuff with CPS, claims of abusing their child, and I was concerned and curious why, with all of that negative stuff that may even negative affect his job and career with government, why he wanted to stay.
And was it true that you felt he was hell-bent on being together?
I know that he really wanted the relationship to work.
Did you conclude that he was never going to let her get away?
I don't know whether that's true, whether or not. I don't recall that.
All right, let me pass this to you and see
Please.
if it refreshes your recollection, if I may.
Thank you.
Does that refresh your recollection, Dr. Quintel, as to Doug's perception of letting Ashley get away from him?
Yes, I said that to the detective. I said it seemed more like I'm not going to let her get away from me.
Referring to Doug.
Yes, sir.
All right, and lastly, Dr. Quintel, did Ashley have anything to say to you about Doug's interest in Emerson and whether or not it was just as...
Objection, hearsay.
Sustained.
Did you reach any conclusions, Dr. Quintel, about Doug's interest in the child as opposed to Ashley?
Objection, Judge.
I'm going to sustain as to the opinion.
Was there an incident on one of these occasions when Doug was in your office that you thought was very strange as it related to the child?
Objection, relevance.
Overruled as long as it's factual.
Yes.
Can you say that question again, please? Thank you.
Was there an incident that you observed that you found particularly puzzling between Doug Benefield and the child, Emerson?
Yes, at the time that I spoke with the detective, I had an appointment and Doug had waited in the reception area, and it was a couples counseling, and Ashley was out in the car with the child, and I thought it was unusual that he didn't go out and see her. Given that they had the relationship they had, it may not be as unusual as I thought, but I was coming from having two little girls and what would be in my mind to do.
And how long was Doug sitting in your office at the time? Do you recall?
Well, it would have been at least an hour. I don't know how long I was in the appointment before.
And in that hour, what you observed with Emerson, the child, outside in the car, Doug Benefield never once went out to say.
I wouldn't have been able to observe that because I would have been in session. I just knew that he was waiting in the lobby. I don't know whether anything other than that.
That's all, Your Honor.
Cross.
So you mentioned that it bothered you, or at least you noticed, when he didn't go out to see the child. How long did you observe Doug Benefield in the waiting room?
I would have seen him when I first went out to grab the client, and then would have seen him when I came back out of my office.
And because of that, you came to the conclusion that he never went out and saw his child?
Yes, I did.
And I believe, correct me if I'm wrong, in your direct examination, you said you met with Ashley Benefield alone 5 times,
Yes, ma'am.
and you met with Doug Benefield alone twice,
Yes, ma'am.
and you met with them together twice.
Yes, ma'am.
So the majority of the time you met with Ashley Benefield, over half of the times you met with her.
To do trauma resolution. Yes, ma'am.
And her discussions with you and her recitations of things played into your decision about this opinion that Doug was being domineering and super controlling, did it not?
Yes, they were comments that she made and frustrations that she had within the system.
So it was not solely based on things that you were observing in Doug Benefield.
No, ma'am.
Thank you. No further questions.
Redirect.
Nothing further.
Can this witness be released?
Yes.
State.
Yes.
All right, sir, you're releasing your subpoena. Thank you very much. Here you go.
Thank you.
Did we publish the couple of exhibits that we put in through Mr. Vizzaccaro?
That's the wrong one.
I don't think that's.
Oh, that's not.
Yeah, one photograph was already in.
One.
and then one we added together with the.
Yes, so members of the jury, we're going to pass these out and publish them. I'm not rushing you, but I'm going to talk while we're doing that. I think at this point, it's a good time for our lunch break. It's about 10 minutes after 12. So take your time. I want you to look through all of this, look through these exhibits, and then I'll excuse you.
26 and 27?
Those 27 and 28, and they'll be marked on them. There's a little sticker on each, which should say 27, 28, and I think the other one is Defense Exhibit 1. All right, so it's 12:15. If I could have you back down in the jury assembly room where you began everything this morning and last week at 1:30. Should give you plenty of time if you want to go somewhere, if you just want to walk downtown. Be in the jury assembly room at 1:30. We'll get you back up here as soon as we can to get started for the afternoon. All right, y'all can have a seat. I would assume, before I let you all go, that the request for an exhibit list from the defense of the items that they expect to introduce has been provided,
Yes.
right? And certainly a list of witnesses that are expected to be called.
Yes.
Right. I didn't get a copy of that. If it's been amended from the witness list that I received, it looks like it was filed June 21st of 2024. So I'll just mark, but who do we have on tap for this afternoon?
So we
I don't need to
have-
know the order, but just who?
We have Jason Alexander, Michael Haig, Haag, Dr.
Hold
Emma
on one
Lou,
second. I'm sorry. I got it. My list is, okay. Michael Haig.
Michael Haig, Dr. Emma Lou,
All right.
and Warren Justin.
Justin Ward.
Warren.
Justin, the lead homicide detective.
All right. None of these, have all these folks been deposed?
Yes.
All right. Are there any objections or anything I need to hear before we get a jury in and get them seated and make them sit there for 5 or 10 minutes while I hear arguments at the bench? I would much, much rather have the objection made, let's talk about it, and then let's call the jury in so it's a little bit smoother.
With Detective Warren, I may have objections, but I don't know what's going to be asked. So without asking what they're going to ask, I don't think we can have that conversation. And additionally, if Detective Gillum is set to testify, I would have similar objections.
You didn't say that name.
No, they've been keeping him here, so. I
Okay.
guess-
You think just 1, 2, 3, 4 witnesses are going to take us the whole afternoon?
Yes, I think there's a reasonably good chance we rest today.
Okay. Oh, is this the bulk of what you're calling at this point?
Yes, sir.
Okay. Well, that would be fine, because then we could do a preliminary charge instruction this evening. Then you guys can decide if you want to do any rebuttal. Okay.
So the one request I do have, Your Honor, is for Mike Haig, who's our ballistics expert.
Mike
We need
Mike
Mike Haig.
Haig. Yes.
J-A-G.
Okay.
We need the HDMI cable to run to the witness stand so he can plug his laptop in.
To where here? I don't understand.
Yes. Projected. Yeah, so it'll be up on the projector.
So he's going to use his laptop to
Demonstrate.
project here. Well, I know this is the one we used. I don't know, Deputy, does that stretch to here?
We'll inquire and we'll check it out.
Oh, you know what? IT has got to come and fix my computer anyway. So can you tell them that we also need
HDMI.
that a witness this afternoon is going to have to run to that?
Yes, sir.
Thank you so much. And then that'll take care of both, because my goblin, just you know how it goes.
Okay,
All right.
thank you, Judge.
I guess the only other questions they would have is there were other witnesses that were held by the defense. If these are the remainder of their witnesses, are those witnesses being released? Because they're asking the state for
We don't know what they're presenting in
Yeah.
rebuttal.
Okay.